Well, welcome to Divorced Critical Estate Planning Issues. Yours, Mine, and Ours takes on a whole new meaning as we dive into the vital asset issues concerning divorce and estate planning. And this is such an important topic because for a lot of people, they don't know that when you get divorced or when you file for divorce or when your property's divided, it does change the whole landscape of your estate plan. So it's something that's very, very important to pay attention to. And my name is Jim Cunningham. I'm a certified specialist. I'm an expert in estate planning. I've been in practice for over 25 years, and we have seen a lot of these issues come up in practice. Unfortunately, it's been a lot of surprises for a lot of people. So what I want to do first before we get started is we do have this disclaimer. I'm a lawyer. I'm talking. This isn't legal advice. So don't look at this and go, oh, great, I'm going to do a bunch of stuff, because no, not a good idea. You absolutely have to seek out an expert lawyer. And we're going to talk about how you find an expert lawyer and the importance of seeking out someone who really knows what they're doing. So I'm going to talk to you about an example. I'm going to talk to you about Katie. Now, Katie here is happy that she's getting divorced. Now, some people it's a tragedy when they get divorced. For other people, it frankly is liberating. I've been married a very long time, longer than I've been practicing law, and I am still on my first marriage. But we are going to go through Katie's divorce and what happens with Katie. So 5 things that we're going to focus on is the first thing is how Katie's divorce affects her estate plan. So this is the estate plan that Katie might do with the spouse, right? I mean, what happens if you get a divorce? What happens to your estate plan? And then secondly, if Katie inherits after her divorce. So in this context, Katie is not the one with the estate plan, but she's the one inheriting the property. So what happens if you inherit after a divorce? It's kind of interesting. What if Katie inherits and then becomes divorced? We're going to talk about that. And then we're going to talk about Katie going back and, she hasn't given up on marriage yet. And then she gets remarried following a divorce. What does that look like? And then we have the issues of child and spousal support. So let's get to it. So how Katie's divorce, her own divorce, affects her estate plan. So there's some real key concepts when it comes to divorce. Something right out of the gate, and I'm talking about California here. In California, registered domestic partner and spouse are interchangeable. So whenever you see the word spouse in California law, it is interchangeable with registered domestic partner. What is a registered domestic partner? Before marriage equality, there was a method where people of the same gender could get married or could become domestic partners. They would file a paper with the county, and it was effectively a state recognized marriage. So those individuals who were married of the same gender could then file a joint return in California, and had some Prop 13 benefits and some other benefits. And then there's also, if one domestic partner is over the age of 62, people who are not of the same gender can become registered domestic partners. And this is really, really important. If you're a recipient of Social Security, or you're a veteran, or the surviving spouse of a veteran, you really need to pay attention to this, because getting married can have an effect on your property. So sometimes it's better to be a registered domestic partner. Now, this is a really crazy one. Prior to the termination of marital status, which is the final court order that says they're divorced, the marriage has been dissolved, Katie's still married. So it's very important to pay attention to this. Just because you file a divorce action doesn't mean that the other person stops inheriting from you. And once you do file for divorce, there's something called an automatic restraining order. Now, I'm a certified specialist in estate planning. I am not a divorce lawyer, but I do know that once a party files for divorce, there is typically an automatic restraining order that goes out. And what that means is you can't set up your own living trust and start transferring titles, but we'll get back to that. So in this weird world that we can live in with divorce, Katie can be legally divorced, meaning her marriage is dissolved, but may not have resolved the split of the property. Now, this is called a legal word, bifurcation, which is splitting the matter into two proceedings. So what can happen is the order comes down dissolving the marriage, but then between the time that the marriage is dissolved and the property's divided, they're not married. And this gets really complicated, frankly, if Katie's gets divorced but does not have a final property settlement agreement or property order with the court, and then the ex dies or Katie dies in that netherworld, that's kind of off topic here today. That is extremely complicated. And I frankly don't see it that often. Katie's property division, in our example, drags on for years and years and years. So we were talking, my wife is talking to a friend of ours who got divorced 5 years ago, and her husband still, ex-husband, still isn't giving his portion of the property. So, you know, these things can drag on for years. So Katie's filing of a petition for dissolution of marriage does not constitute divorce. Very important to understand here. Katie and her ex are still married until a judge dissolves their marriage. And then there's typically a bifurcation in most cases if you have assets. What is the effect of a divorce on a couple's estate plan? So we talked about divorce concepts in general. Here's something very important to understand. X, this is Katie's ex. The ex is deemed to have died before Katie at Katie's death for payable on death or transfer on death beneficiaries on bank accounts. So let me kind of unpack this here. If Katie dies and they are not married, if it's her ex-spouse who survives, and Katie had a bank account that said, you know, when I die, my ex is the beneficiary. Let's say she set that up when she was married, and she never got around to changing the beneficiary or changing the payable on death beneficiary designation on a bank account. The ex cannot inherit. Now, can the ex go in with the death certificate and get his hands on the money? Absolutely. Is he legally entitled to it? No. Is it stealing? I don't know, right? But this is something that's really important. When Katie gets divorced, her divorce attorney will hopefully tell her, Katie, you need to retitle all your assets. You need to look at everything. You need to look at who the beneficiary designation is, because if you don't get around to doing it, your ex may effectively steal the money, like lowercase s, steal the money. Brokerage accounts. So this would be an account, you know, a stock and bond account, a compensation plan, pension plan. So those are employer-related plans. Not a non-IRA employee benefit, non-IRA employee benefit plans, living trusts. So, but the exception here is not life insurance. So on the IRA, the beneficiary, you stop being the beneficiary when you get divorced, but you're still on there. So the ex is still on the beneficiary designation. When Katie dies, the ex can get his hands on the money. The weird thing about this, and when I was preparing for this, I was reminded, the weird thing is life insurance is somehow excluded, and I frankly don't know why. I don't know why they carved out life insurance. Who knows? So here's the takeaway. If Katie doesn't want her ex to get her life insurance, Katie needs to change the beneficiary designation unless a court says no. And I have seen many instances where a court will say, Katie, you have to keep that life insurance going, you know, while the kids are minors, and you have to make the ex the beneficiary. I've seen that in many court orders dividing up the property. That's very common to see. If the ex can prove by clear and convincing evidence, so notwithstanding everything we just said, if the ex can prove by clear and convincing evidence, which is, you know, super, it's not quite as high as, you know, beyond a reasonable doubt, but it's just shy of a reasonable doubt. Clear and convincing evidence that Katie intended her ex to get the proceeds, again, or a court orders it, then the ex gets it. The best clear and convincing evidence is if Katie reaffirms the payable on death beneficiary designation on the bank account. You know, just because she's divorced from her ex doesn't necessarily mean she doesn't want her ex to inherit. It might be the case, but I've seen certainly many instances where an ex-spouse will leave something to a, you know, to a former spouse. But the best example, right, is to fill out the beneficiary designation. That's obviously clear and convincing evidence. The ex is completely removed from Katie's will. Very important to understand. So if Katie had designated her ex as her executor and she gets divorced and still wants her ex as her executor, she's got to visit with her estate planning attorney and redo her will or republish her will. That's really important. And again, the ex is completely removed from Katie's durable power of attorney for property and for healthcare. So and I've seen plenty of situations where a couple is divorcing and they have no kids and they might've been married a long time. They still have each other in decision maker roles, but they just, you know, they don't want to be married anymore. And again, courts are free to make orders altering any of these laws that we talked about on this page. So a court has the latitude to order whatever, and they have to follow the court order. And if Katie ignores it, then the ex can go to court to enforce it. So something really important to understand, there's something called joint tenancy. Now, joint tenancy is a way of holding property, and you might see this on real estate or bank accounts. But basically, Katie and her ex are joint tenants on their home. This is not an uncommon situation. And the joint tenancy means that the survivor inherits everything. So the last man or the last woman standing gets the property, notwithstanding a will, notwithstanding a trust. If two people own property as joint tenants, and in California, it is implied, a right of survivorship is implied. That's not the case in all states. But Katie cannot inherit from her ex because only surviving spouses can inherit joint tenancy property from another spouse. So only, now what's a surviving spouse? Let's say Katie and her ex, they're not yet divorced. Her ex dies. Katie is the surviving spouse. That's a legal term that we use. So Katie cannot inherit from her ex because only surviving spouses can inherit from joint tenancy property. So this kind of raises this issue, and this is why it gets complex with Katie and her ex. They get a divorce, and then somebody dies before there's a final property division, and there you have this automatic restraining order in place. You know, if Katie dies, the ex in this case would not get Katie's, would not get that other half of the property that Katie owned. It would be distributed under Katie's will. So when the court dissolves Katie's marriage, she's no longer joint tenants with her ex. Very important to understand. So if you have gotten a divorce or you're thinking about it and you own joint tenancy property, I'm sure your family law attorney will cover this with you. Katie's joint tenancy is severed at dissolution of the marriage, and the survivor does not inherit everything. But if Katie legally separates from her ex, this provision does not apply. A legal separation is like a divorce of the money, but the people stay married. Now, many people will choose for religious reasons or philosophical reasons or whatever reasons to be effectively divorced, to sever their property and to each take their respective portion of the property, but still stay legally married. So an ex can, if an ex can provide by clear and convincing evidence, can prove by clear and convincing evidence that Katie wanted the ex to be the beneficiary, then the ex gets it. Again, a subsequent beneficiary designation, some type of writing that reaffirms the survivorship nature of the joint tenancy. But again, you want to seek out expert legal help with your estate plan following a divorce, because this law of unanticipated consequences, the law it applies to everybody equally in our country. So it doesn't apply to one group and not to another group. It applies equally to everyone, but everyone has their own unique story. So it's very important to seek out expert legal care, because they can sort of match up your story with the law and make sure that the people who inherit from you are the people that you want to inherit in the way you want to inherit. So there's some legal issues during the divorce proceeding. I mentioned there's a blanket restraining order about transferring assets. And so Katie or her ex cannot transfer assets during the dissolution proceeding. Katie can make a will. She can certainly amend her half of the joint revocable trust. So many times clients will have a joint revocable trust with assets in their trust, and one spouse can certainly amend his or her portion. Within the confines of the document, you have to do it as the document provides. Katie should ask her divorce lawyer when she's no longer under the restraining order. And sometimes a court lifts that restraining order in certain circumstances, perhaps if one spouse is sick. Once a court has ordered the property divided, this is really important, folks. Once you have a final property order from a judge, the living trust winks out of existence. It goes away, because a trust has to have two really important things. Number one, it has to have a trustee, and number two, it has to have assets. If you don't have either one of those, arguably your trust doesn't exist. So it goes away. So in this case, the assets that were in the living trust were ordered transferred to Katie and her ex. And once that happens, then the living trust is no longer in force, right? So you got a problem potentially there. So Katie's divorce, first the dissolution, and then the fight over the community property versus separate property, then custody and support. Let's say she's got a house of $800,000, her and her ex, and her ex buys her out of the house. There is likely going to be a partial reassessment, because remember I said that the dissolution happens first and then the property is divided later. when you transfer property between people, oftentimes that property gets reassessed. So you have to be very careful. You have to pay really good attention. And even if you're going through a divorce, there may be ways where you don't get reassessed, but the divorce lawyer should check out with the estate planning attorney, an expert estate planning attorney, and certainly our firm does this, to make sure that you do whatever you need to do to potentially avoid reassessment. This is very important. So Prop 13 is a very important property right in California. A qualified domestic relations order splits the 401k. So that'll be a court order. And let's say in this case, they have a $200,000 401k. Well, 100,000 might go to the ex and 100,000 would go to Katie. Even though that's Katie's $200,000 401k, it takes a court order to split it. And then the property's divided. And then you have custody issues with kids that can get really ugly. You also have potentially spousal support and child support, which we'll talk about in a little bit. So what if Katie inherits after her divorce? Right? So now what we're talking about, we're talking about something a little bit different. So before we were talking about Katie and her own estate plan. Now we're going to talk about inheritance. What if Katie inherits after her divorce? What does that look like? Why do we need to talk about that? Well, when Katie, the divorced inheritor, now this is not a legal term, but it's something to maybe help you understand what I'm talking about. Katie inherits following her divorce. This is really important. And I was actually called as an expert witness on a case a few years ago. A court may re-examine spousal support and child support because Katie's assets have increased. So you remember we had Katie with an $800,000, or Katie and her ex, an $800,000 house and an IRA, and then, let's say Katie has some spousal support to pay and some child support to pay. If Katie inherits a couple $1 million, now her assets are significantly bigger. That might cause an increase in the child support. And it's very important to understand that child support is the property of the parent receiving the child support. It is not the property of the child. So this goes to it is effectively reimburse the custodial parent or the parent receiving the support. It's effectively to reimburse them for the expenses associated with raising the child. What if Katie never gets around to updating her estate plan? But let's say Katie dies and she's got some minor children. Who do you think is going to be in charge of the money for the minor children? It's probably going to be the ex. And oftentimes people get divorced because of money problems. So Katie is really going to want to take a close look that if she passes away or she gets sick, who's in control of the money? Really important question. What if Katie is deceased when she inherits? So what does that mean? Well, let's say she's passed away before she inherits. Now, how can you inherit if you're passed away? Her parents survive her, and maybe her parents don't change her estate plan. Maybe they can't, maybe they're in a nursing home. Maybe they lack capacity. Who's going to inherit Katie's inheritance? Well, again, it's probably going to be Katie's children. It's not going to be the ex. And then who's going to be in charge of the children? Well, if the children are minors, it's going to be most likely the natural parent. So if you have a Katie, right, and you're leaving something to Katie and you have grandkids, you really need to be mindful of who's going to be in charge of that money for the grandkids, because many times, certainly if they're under 18, they lawfully cannot have more than $5,000, right, that somebody else gives them. And certainly if they're over 18, they may not be the most responsible. And, it makes sense in this case, it really does make sense for Katie's parents to protect Katie's inheritance from creditors, predators, and divorce. Now, what do I mean by this? So what do you do? Here's what Katie's parents, and in this case, I'm just saying her parents are leaving her money, just to make it a clear example. Here's what Katie's parents can do for Katie. They can create an inheritance protection trust for Katie inside of their own living trust. So what this means is when the parents die, Katie can inherit the property, and the assets of the trust are available for Katie's needs, but they're not owned by Katie. And this is really important. So there's an adage in creditor protection law: whatever you can get to, your creditors can get to. And so what we do is, for probably 80% of our clients do this, if not more. They set up their inheritance. They may leave $1 million to Katie in a trust. Katie is the trustee. So when the parents die, this trust springs into existence that the parents have already set up. Katie cannot do this once her parents pass away. And Katie is in charge of that money. And what happens is if Katie does not, sees some trouble brewing, oh man, my ex is coming back for some more spousal support or child support. There's functionality in the parent's estate plan to remove Katie as trustee so that Katie is no longer the trustee. So now she doesn't have access to the money. So she doesn't own it. She doesn't have access to it. And any distributions are capped any distributions to her are capped at 25% going to child support and spousal support. So we'll talk about that in a little bit. This is a really powerful tool. So many of our clients, they say, you know what? I really want to protect my kids' inheritance from divorce. So let's say Katie inherits before she divorces. And I can't tell you how often we see this. We handle in excess of 300 or 400 matters a year when people pass away. So we've got a whole team in our firm dedicated to helping people after somebody gets sick or passes away. And here's what we see a lot. We see a Katie inherits, and then soon after, her ex files for divorce because the ex has been waiting for years for Katie's parents to die and Katie to get her inheritance. Now they have enough money to get divorced, right? So sometimes people can't get divorced because they don't have enough money to get divorced, right? But now with this inheritance, it now is going to be a big issue in Katie's divorce with her ex. So something to understand, all property acquired during Katie's marriage is presumed community property, except property acquired by gift or inheritance, which is presumed to be separate property. Now, these are presumptions. These are rebuttable presumptions. And I will tell you that a divorcing spouse the ex, Katie's ex, will argue at some point in the proceeding that her inheritance has been transmuted to community property. Why? Because if the ex wins, the ex gets half of Katie's inheritance, right? So it's going to make sense for the ex to say, yeah, Katie told me that she really wanted me to be on this with her, or she added my name to the account, or she used this money to pay our community expenses. Whatever the story is, this will be in play in the marriage, and it will be an issue when it comes to dividing up the property and paying support. So the question is, was there a transmutation of separate to community property? So, and frankly, it's not uncommon for Katie to treat an inheritance as community property because many people are inheriting when both of their parents have passed away. Sometimes when when one parent has passed and there's a surviving parent, if the parents are divorced, perhaps, but many times it's on the death of the second parent. And frankly, when your parents die, when my mom, when her father died, who died after her mother, she says, and she was in her 50s, she goes, I'm an orphan, right? So I think it's natural to gravitate toward your spouse when you lose your parents. And it's not uncommon for people to treat separate property as community property. So again, it makes sense to protect Katie's inheritance from creditors, predators, and divorce. And again, her parents can set this up in the parents' living trust with the inheritance protection trust. So again, they create inheritance protection trust for Katie inside of the parents' living trust. After Katie inherits, Katie can be the trustee. The assets are only available for Katie's needs. And this trust protector function, it's like a superhero. A trust protector, for those of you who haven't heard of what a trust protector is, a trust protector is an individual who has power over a trust, but who is not the trustee. A trust protector is a person who has power over the trust, but who is not the trustee. Frankly, a court has this power. So all the powers that a trust protector has, arguably a court has those powers. So what we're doing is removing those powers from a court to an individual. And I serve as trust protector on hundreds, if not thousands of trusts at this point. And so I'm the person who is typically there to help out when the need arises as an alternative to a court. So in this case, the trustee can remove, the trust protector can remove Katie from the role of trustee. And now Katie has no access to those funds. She's a beneficiary of the trust, but the trustee certainly has discretion to make distributions to Katie or not make distributions to Katie. So it's a method of protection. And basically what this does is this helps Katie negotiate a better outcome, frankly, than if the parents had not set this up. So if you're a parent and you have a Katie, you need to be considering this. And certainly if you've been through a divorce, I will tell you that you're probably thinking about it more perhaps than couples who have not been through a divorce. So something very, very important to consider. Let's talk about remarriage. Let's say Katie gets divorced and then she remarries. Well, what does that look like? Again, what Katie brings to the marriage is Katie's separate property. So property acquired during the marriage is presumed community property, but property you bring to the marriage is separate property. Only spouses can own community property. So, you know, if you're a single person, you legally cannot own community property. So by definition, when what Katie brings to the marriage, only single people can get married. What Katie brings to the marriage is Katie's separate property. So absent a premarital or prenuptial agreement, all property acquired during marriage is community property. So if you want to opt out of the community property system, you need to meet with a lawyer, a separate lawyer from the person that you're marrying, and you need to consider a prenuptial agreement. Now, in France, they have a different system. You check a box, which is very French. It's either everything's community, everything's separate, or it's California's where what you bring to the marriage is separate, and then going forward, everything's community. So we have a different system here that involves lawyers, but the continental system in France is a little bit different. Again, transmutation of separate property to community property. Now, Katie can have her own revocable trust plan. And so, you know, typically what we recommend when clients are getting remarried is we recommend that Katie makes up her estate plan, but it's very important. She needs to do this before and after she gets married. So you do the prenuptial before you get married. She should have an estate plan before she gets married. But once she gets married, unless she reaffirms her estate plan, unless she says, now I'm married and I want to leave to my spouse, or I don't want to leave to my spouse, whatever it is, she has to do that. Otherwise, her new spouse is called a pretermitted spouse, meaning if Katie does a will or a living trust and then gets married and does nothing else, that spouse is going to inherit potentially all of Katie's property, but at a minimum, a third or a half. So if Katie has one child, the spouse would inherit half the property. If Katie has two children, the spouse would inherit a third of the property. So it's just important to understand, if you do get remarried, or in this case, Katie gets remarried, she certainly can do a prenuptial agreement, which on second marriages, not the first marriage, a lot of people do, not so much the first marriage, but typically the second, third marriage. But you can have double protection. So we call this belts and suspenders. You can have double protection, meaning you do a prenup and Katie does her own trust and kind of keeps that money separate, and her spouse has his or her own trust, keeping that money separate, and they might have a joint account for household expenses. So let's talk about child and spousal support. Again, we're not going to talk about the family law issues related to child and spousal support, but I do want to tell you something that as an officer of the court, it's my obligation to tell people to pay their child support and their spousal support. It's my obligation not to do anything that would violate any law, which we'd never do. But as officers of the court, if a court orders you to pay child or spousal support, you need to pay it. So child support, as again I mentioned, is the property. In this case, Katie is the one paying the child support. It's the property of the ex and not the children. Katie's inheritance can influence the amount of court-ordered support, so that is an issue. And so what we're talking about here is Katie getting divorced and then inheriting. So if the parents want to keep that off the table, so to speak, in terms of not juicing up her assets, so she has to pay more support, the parents should consider the inheritance protection trust. A spendthrift provision is limited. Now, what a spendthrift provision is, if Katie is the beneficiary of a trust and someone else is the trustee, all right, Katie cannot encumber, hypothecate, or borrow against her distributions, and they're free from the claims of her creditors, except a court can order up to 25% of the distribution to Katie be paid to satisfy any creditor, but can be, meaning if Katie's getting money, up to 25% of what's coming out can be ordered to be paid to creditors, including child support and spousal support. So it's very important to understand that there's this potential 25% chipping away of the spendthrift provision in California. But of course, once the other 75% hits the bank, the creditors are free to seize that too.